Acknowledge all the distinguished judges, the honorable judges, the distinguished guests, special guests, my fellow speakers, and all of the participants today. Thank you all very much for coming. This is an excellent and a wonderful opportunity to speak to you because this is like a birth. It's like the birth of the Ciarb branch in Pakistan, Lahore. And this birth came after a long gestation period, I understand. It took at least 4 years to get registered, etc. So it was very difficult words, but I'm glad we're all here to celebrate this wonderful event. So it's a great pleasure to be here, and I echo the words of my previous speakers on how wonderful it is to be speaking to you on the story specification. Now, the topic that we're to speak on, and I looked at the word standardization. And what is the role of standardization in terms of the process and procedure of arbitration? And the answer is a lot and very little at the same time. The reason I say that is because, as you may know, I also teach arbitration mainly to the Chartered Institute of Arbitrators. I teach award writing, I teach arbitration. I taught the intro course about a week ago, and so I dabble in all of the different courses that the Ciarb has. And one of the things I tell the participants in my courses that is the flexibility is one of the hallmarks of arbitration, along with confidentiality and the party autonomy, the ability to choose a lot of the aspects of an arbitration. Flexibility is a very important item. So you don't want to get standardization in conflict with the flexibility of arbitration, because we have to be able to ensure that arbitrators continue to have that discretion. It was referred to in the morning session about the rules of court. And you have to stick to the rules of court. And when you're in court, you have a rule book this thick, full of rules you have to adhere to. Arbitration's not like that. It's both the parties who choose a lot of the procedure, as well as the discretion of the arbitrator is such that the arbitrator who has experience can ebb and flow, can use the procedure to make sure that the arbitration runs more quickly, more efficiently, more economically, and achieves a fair result and a good enforceable award, which is the product of us. Now, when you talk about standardization, I say it should be standardization of basic principles only. And it should be, I look at 3 areas: arbitration itself, I look at enforcement of awards, and I look at training. Now, when we look at arbitration itself, there are many things in standardization that we need to adhere to. And the first, of course, is the model law. And I've heard a lot of discussion, very hopeful discussion. This is a very hopeful conference because it's very hopeful that the model law entered the law of Pakistan, which would be a very, very good step. Because as stated, as you all know, traders and commercial people like certainty. And that's what this level of standardization gives you, is some amount of certainty, so you know what the arbitration law is that you have before you. Another example of standardization was the UNCITRAL rules, where it's a best practice document along with some of the others. UNCITRAL rules you can use. In modern law, it has to be a document to the best of law, as you know. UNCITRAL rules are something we can use every day, and I do have cases using now, and they're very useful. There are other mechanisms with standardization in arbitration. ICA, which has been referred to before, issued guidelines on the standards of practice in international arbitration in March of 2021, for example. And many other organizations have given basic principles, but I have to emphasize that that's what these are basic principles. It should not be a standard rule book as thick as the rules of court, telling us how to hunt an arbitration or setting down chapter and verse from paragraph 1 to paragraph 3021, exactly what an arbitration should consist of. We also have the idea guidelines of pardon representation, for example, which gives an idea how arbitration should be run and how parties should be acting, and how parties should conduct themselves, all very useful. We also see a certain harmonization of the institutional rules, the opening, when we see various rules going in particular directions, adopting new procedures, and these are all very useful, and they're all a sort of standardization. So if one set of rules goes into multi-party arbitrations, then often occurs other rules follow suit. And it's the same with many of the ideas we see in the new LCIA rules, which repeat what other rules they'll put in place. And I think that's all very useful. Yeah. So you can see that in arbitration, the level of standardization should be at a basic principles level. We don't want to occupy or if we encumber arbitration with too many hard and fast rules. And that's, I guess, where the soft documents, the soft law documents come in. The idea rules of obtaining evidence, frag rules, if we want those things guide discretion, but they don't necessarily demand compliance. So, as I say, arbitrators need to have a lot of discretion, but they need also to have a best practice document to guide that discretion. The second area where some standardization needs to occur is in the enforcement of awards. I did a small research paper a decade ago looking at the enforcement of awards in various countries. Very small paper, it's not large, but what came out of that, and actually came out off the back of the IDA conference, which is held in Dubai 2011. What you saw from that is that it depends on the level of sophistication of the court who has the enforceable challenge before it. So if you have courts in rural places in certain countries, the judges just may not know about arbitration and know how to enforce an award, etc. It's just a matter of training, education, familiarization. As I mentioned to some of you, I was on a panel in 2008 in Dubai with the local judges, and to explain to them that they should somehow enforce an award written by Yi, a Canadian, who just landed in their lovely country, here and takes them for the judicial-like decision that they're supposed to enforce. Well, that was kind of, they had to have a little bit of discussion around that to see how that felt, why they should actually do that. So there needs to be a lot of education, a lot of discussion, a lot of familiarization with courts on enforcement. That's a sort of standardization of will. I mean, we have the New York Convention, which is a brilliant piece of work. It's a treaty that actually works. It's been around since 1958. And it is adopted by 169 countries and counting. And it allows for enforcement, which is one of the other pillars that makes arbitration work. But we need to ensure that courts are familiar with it and know how to use it. I think that's CI. The last area is training, and I know from my work through the Ciarb Institute of Arbitrators, we have done a lot of standardization in our training. Ms. Dixon could refer to that because obviously when I started teaching Ciarb Institute, we produced our own cartridges of information, do this sort of based on certain guidelines in the international section. Now we have, it's all standardized throughout Zurowitz, as far as I know. We have standardized packages, so I see, but it is. And that's very, very useful because although we felt we were doing an excellent job, perhaps other places in the world were not. not quite in fingers, but that is a step there. That could be a suggestion. So as a result, standardization works in terms of training. And there has been reference to training, legal training. I'm referring maybe to arbitration training, which is the area that I'm interested in. And of course, there needs to be a lot more arbitration training in many countries. In talking to some of my colleagues here in Pakistan, it sounds like this is a right area for arbitration training. And of course, we'll assist in any way that we possibly can with setting up training by Pakistanis for Pakistanis in terms of arbitration. Justice Jawad Hassan earlier this morning gave assurances about the rule of law. The rule of law is crucial in all of this, so I was partnered to hear that, and we'll put you. Now, the last point I want to state is why you even pick about standardization. Well, the full point, even of commercial arbitration, not investor state, but of commercial arbitration, is to make the trading and commercial landscape somewhat understandable for traders and commercial people. They want some level of certainty, some level of security. They want some level of certainty so that their lawyers, the transaction lawyers, can say, yes, you can enter into a contract with a company in that country because you can sue under that contract, you can arbitrate under that contract, and it will be dealt with fairly. And I can predict to you that if this is that situation, now from the outcome, so that's the whole point of standardization at the end of the day, is for people in many countries to be able to produce an enforceable award, or courts to enforce those awards, for there to be a good stock of arbitrators and counsel familiar with arbitration, and for commercial people at the end of the day to understand what they're getting into when they sign a contract and to know that they have some recourse if they have to speak. Thank you.